So, what kind of exceptions to the general rule are there? In situations involving unilateral offers where the offeror did not expect or require notification of acceptance. Carlyl and carbolic smoke ball. I don't need to know that you've been taking the medicine on time unless and until it impacts my revenue. Secondly, where an offer expressly or impliedly provides for acceptance to be communicated in a particular way, so that acceptance is deemed communicated when the manner is adopted, whether or not actually received. So if our agreement says, if you're going to send me a notice under section 54 of this agreement, which happens to be the clause that allows you to terminate the contract, you can only send that to me by carrier pigeon. Then the fact that you've emailed it, tweeted it, put it on Grindr and sent it in the mail doesn't matter, because we've got a clear process for you to deliver that kind of information. I'm not quite sure that that clause would hold up, mind you, for a range of different reasons, but you might like to think about what they are later.
Sometimes it's more, I've got one of the moments, is saying you don't have to communicate, or you can communicate, but if we continue to do work, then it's deemed accepted.
Yeah, we've talked about that concept. That's an interesting thing. So let's actually talk about that. There is actually a case that we'll get to today that is that situation, actually, a very similar situation. So I'm thinking of the Paul Architects case. So let me see if I can find that one, and we'll just flick through to it to just, Paul, where are they? Oh, sorry, I can't find the case now. So in this particular case, where's it gone? Don't tell me I culled it in trying to get this into a smaller lot of slides. Empinal. Oh, maybe it's not in this pack. Maybe it's in the. I'll find it in a minute. So in this particular case, we have a firm of architects. I think they were architects or engineers who were working on some sort of development. They're working with the builder. A couple of written documents were put in front of them. They say, oh, no, we don't like contracts. So the director in particular doesn't like to sign contracts. We only work with people we trust. We think it's too confining. We don't want to sign a contract. And the other company said, well, for using our services, this is our standard contract. Sent it to them. They were asked to do work. They did some work. The company that liked to trust its suppliers and be trusted by them went into liquidation. So the question was there a contract? Had they promised to pay in accordance with the standard terms for the other side? And so what happened? Does anybody remember? This is McMahon, Paul, Empinal Holdings and McMahon. Do you remember what happened, LJ? SJ?
Yeah, it's fascinating. They wrote to them saying that they, even though nothing had been signed, the architects wrote to them saying that they were proceeding on the basis that there was a contract, and they were, even though there was silence, they did the work and received payments.
So it wasn't mere silence, there was work actually done. Now this is the opposite way from what you're talking, and the court found that there was a contract, didn't it?
Yep.
So it said, actually you were given the terms, you had the opportunity to reject or negotiate the terms, and then you requested work without varying the terms, and the work was done. So that's basically, that's your acceptance of the contract. So silence is not enough, but some activity that demonstrates acceptance and demonstrates the meeting of the minds is enough. And the situation that you're talking about, Michael, is where, put your hand up if I'm giving away facts that you're not comfortable with me sharing here.
So this was more just an example of how you could write into your contract.
So they're saying we provide professional services. From time to time we might change our fees. I'm just using this as again. From time to time we might change our fees. We'll notify you and you can tell us if you don't agree or if you do agree, but if you ask us to do work, we're going to treat that as you agreeing. Now, the changing of the dollar amount I might have added in there, I think it's particularly in legal practice. I mean, I think my own engagement letter says that. It's like, these are my terms of engagement. You need to consider them. The bit I always find quite amusing is if you need legal advice, you better go and get independent legal advice. You know, it's such a gorgeous thing to send your clients away to get legal advice on the contract that they have with their lawyer. But anyway, go and get some independent legal advice if you need. If you accept it, if you agree, sign on the dotted line and send me a copy. If you don't sign on the dotted line and send me a copy, but you ask me to do work after you get this, and you don't mention any problems with it, then I'm going to treat this as our contract. And contract law would say that works. It's the variation piece that I'm less comfortable with. So particularly if the variation price is backdated. Justin.
So basically, this is the inferred case, and then
Inferred, yeah.
is the conduct implies acceptance.
Yeah.
And silence.
Yeah, so that's where I should be looking for it, is in this idea. It's probably in the next slide, you never know. I'm trying to cull these slides, but I find this stuff so interesting. I think, oh, we should talk about this, we should talk about this, and I keep adding to them. So you just need to accept, we don't need to go through every slide. They're just kind of there to give me something to base my discussion on if I need to. Where are we up to now? Of course, it's on the next slide, wouldn't you know that? There I was looking for it everywhere. Match and Paul, that's right, Empinol holding a match and Paul. So basically silence by itself is not enough. So, and hiding, you know, and we see this all the time, and I've seen lawyers do it. I've seen lawyers send out letters of demand that's, you know, will basically say, or actually more responses to letters of demand. We'll agree to pay you X instead of Y. Here's the check, or here, actually not even here's the check. If we don't hear anything from you by Monday, we'll assume that that's okay. Actually, somebody here, I can't remember who it is, was talking to me not long ago about there's quite a common internet, or I don't even call it internet postal fraud thing that goes on, where people will receive letters that basically say things like, you've been nominated to be in Who's Who, or in some journal, or something like that. If we don't hear anything from you by next Wednesday, then we'll include you in the print, and it'll cost you $1,000. And they just then they start sending the bills. Not at all. It's, you know, it's a scam that's been going on for a while. Silence is not acceptance. It's okay to throw those emails in the bin, or those letters in the bin. So the test, which comes from Empinol, is whether a reasonable bystander would regard the conduct of the offeree, including their silence, as signalling to the offeror that his offer has been accepted. So complete silence, absence is never going to be enough, but a handshake might be enough. A wink might be enough. Activity, the way that you conduct yourself after the offer has been made might be enough.
I haven't read the full case on that. How did delivering the TV in latex not?
Remember, the contract in latex, this is between the finance company and Mr. Knight. So it's actually there are two contracts there. One is the contract to purchase the television, which was a contract between Mr. Knight and the TV company, the shop. Let's call him Harvey Norman. So there's that one contract, and that contract was essentially, we'll deliver you the TV when we receive the finance money. Now, my guess is, I don't remember the facts in detail, but my guess is that what's happened is he's put his form in, it's been approved for finance, the money has gone from the finance company to the Harvey Norman equivalent, the TV's then been delivered to his house, he's received no communication at all, he's then returned the TV, the shop's probably done nothing about telling this poor finance company, I do feel for them, that they've just kept the money, or they might have, you know, like these companies do huge amount of business, they've just done an offset somewhere along the way, it's just got lost in the bowels of time. And of course Mr. Knight's made no communications because he hasn't needed to, he's returned his TV. So as between, and if the shop's is accepted it back, now it might be that there was a binding contract between them, he might actually have had no right to return it. But you know, in a choice between litigating over a TV that you could sell to somebody else and just taking it back, most shops would take it back. It's not a big
Sounds
deal.
like the finance company probably should have litigated.
Yeah, they may have actually chosen the wrong defendant, absolutely. Again, I don't know enough about how that actually plays together. And they're quite complex arrangements between those finance companies and the shops. So often, and you know, even back when this was, those retailers make more money out of the commission for selling the finance than they do out of the profit from the goods that they sell. So in fact their businesses are reselling finance, that's where their profit line comes from as opposed to the shop, which is one of the reasons why it's an industry that's become very heavily regulated, because particularly commission-based sales agents are much more interested in selling the finance than wondering about whether or not the person to whom they've sold finance can pay. So. Felthouse and Bindley, why have I put this in a separate spot? Oh, this is another one on silence. So, again, another nice horse case. So there was an uncle who was interested in buying his nephew's horse, and he wrote to the nephew, who was selling a whole heap of things, and said, if I don't hear anything more about him, I'll consider the horse mine at £30 and 15 shillings. The nephew had engaged Mr. Bindley, who was an auctioneer, to sell all of these things. The nephew didn't actually write back to his uncle, but he did say to Mr. Bindley, keep that horse to one side, I'm going to sell it to my uncle. In the end, Bindley sold the horse to somebody else. So the uncle sued the auctioneer in tort unsuccessfully. So then the uncle went and sued his nephew. So the question became, is there a contract between the uncle and the nephew? Put the answer on the slide. I hate slides. So, Justice Wiles said there isn't a contract between the uncle and the nephew because there was no communicated acceptance. The fact that the nephew was happy to sell to the uncle, that he had subjectively accepted, wasn't enough. There needed to be some act where we could objectively see that there's been a meeting of the minds. So while the nephew in his own mind intended his uncle to have the horse, he hadn't communicated the intention to the uncle or done anything to bind himself. Communicating the acceptance to the auctioneer isn't enough. Acceptance needs to be communicated to the offeror. So no contract between the uncle and the nephew, meaning that the uncle didn't own the horse, which means that the auctioneer wasn't actually dealing with the uncle's property outside of instructions at the time that he sold it, because he had instructions to sell things that belonged to the nephew.